Now, in today's video, we're going to be giving you an update. Candidly, not a particularly good one, in a case that we have been following called May v. Bonta. It's actually two separate cases, one that were joined together. One is May v. Bonta, which deals with California law. The other one is referred to as Wooliford. This deals with Hawaii law. And it's been joined together at the appellate level, dealing with sensitive locations. Now, a little bit of a backstory so you understand how we've got here. After the Bruen decision, the states, well, most states obviously were already in compliance with Bruen, but a new constitutional test was developed as a result of the Bruen decision. This is the famous history text tradition approach that myself and countless other YouTubers have talked about, and you probably are already well aware. The primary holding of Bruen had to deal, obviously, with CCWs, and this required states like California and Hawaii to update their penal codes to allow for shall issue. And essentially, they needed to make sure that citizens could, in fact, be able to carry firearms outside of their home. They were infuriated by this, and they made no bones about that. And they decided that while they would have to give a CCW permit, they could heavily regulate where you could carry that gun, even with a CCW permit. And this involves sensitive locations. Keep in mind that in the Bruen decision, both in the majority opinion authored by Justice Thomas as well as the concurring opinion authored by Justice Kavanaugh, there was a discussion involving so-called sensitive locations. And both of them said, hey, listen, at the time of the ratification, there were certain very specific locations where you could not carry a firearm. These were places where there was likely to be, as Justice Thomas articulated, inflamed passions. And more specifically, these were locations where they could state with particularity, you cannot be here with a weapon, and the state has taken proactive measures to protect individuals that are in those locations, specifically courthouses being an example of that. Well, both California and Hawaii said, okay, well, fair enough. We'll go ahead and we will essentially, we cannot say all of Hawaii or all of California is a sensitive location. That's already been prevented by the language in Bruen. But we can go ahead and we can say, look, every square inch of California effectively, or every square inch of Hawaii is a sensitive location. And I know that sounds like a distinction without a difference, and frankly, it is. But what they did was they started listing all of the locations where you could not carry a gun. Taken in its totality, pretty much wipes out almost all of these states. You know, for instance, you cannot carry your weapon into a location whose sells alcohol for consumption on premises, whether or not you are drinking. This also includes the parking lots that service these locations. So if you are driving to your local dry cleaner, and at the, in the strip mall that the dry cleaner is located in, there happens to be a small Mexican restaurant that serves beer, even though you're not going into that restaurant, because you're in the parking lot that services the restaurant, technically speaking, you are outside of compliance. Now, there was a judge, Judge Carney in Orange County, that was asked to rule on a preliminary injunction preventing this law from going into effect on January 1 of last year. Okay, guys, so I'm pausing this video for just a second. USCCA, which sponsors these videos, they're doing a giveaway right now. It's very cool, and you're going to want to get on it. You can see all the details in the descriptions below the video, but it is time sensitive. So click on that and definitely participate. All right. With that, let's get back to the video. he granted the injunction. In fact, famously in his opinion, he said that, the sensitive locations are noxious to the Second Amendment. The state appealed, and it went before the Ninth Circuit Court of Appeals. It went before a 3-judge panel. Now, the 3-judge panel did something, and I actually made a video about this, that I found to be incredibly problematic. This appeal was not an appeal on the final decision. The trial on whether or not these sensitive locations have any constitutional validity has not yet happened. The only thing that we're dealing with is a preliminary injunction to prevent the law from going into effect while the trial is in progress. And so this is what we call an interlocutory appeal. When there is an interlocutory appeal, the appellate court is limited to reviewing based on what we call abuse of discretion. Are there no other justices in America that would come to the same conclusion as the trial judge? Now, in a final opinion at the end of the trial, then the court, if it's being appealed, the court can then review the case, what we call de novo. They get to start basically from the very beginning. Well, in this particular instance, a 3-judge panel at the Ninth Circuit Court of Appeals said, look, we are limited to abuse of discretion, but essentially we're going to go ahead and review de novo. We're going to go ahead and go beyond the scope of our authority. Now, they didn't specifically articulate that. They just simply did it. In any event, this in and of itself, I felt, was grounds for appeal. Now, the proper venue is that once you have prevailed, once you have lost at the 3-judge panel level, you can then appeal to what is referred to as an en banc review. This is when now an 11-judge panel reviews the decision of the 3-judge panel. Lose the en banc review, you then appeal to the United States Supreme Court. That's sort of the pathway. So the 3-judge panel erroneously sits there and says, well, Judge Carney, he got some of it correct, and we are going to allow an injunction to be in play for some of the locations that the state said you can't carry a gun, but other areas he got wrong, okay? And they did their own sort of bizarre Bruin analysis to come to this conclusion. And it's disjointed. In fact, it makes no logical sense. They even tell you in the case that it makes no logical sense. And we'll go back to that in a minute because that part is really telling and explaining what these 3 justices were trying to do. Anyways, an appeal was then made for an en banc review. This was understandable. Now, it's not an automatic hearing when you apply for an en banc review. The judges have to agree to that, very similar to the Supreme Court, deciding whether or not they're going to grant cert. If the circuit court decides, you know what, we're not going to hear the en banc review, then the 3-judge panel's decision is upheld effectively. Now you have your pathway to the Supreme Court. Okay, so what did the en banc panel do? Well, the en banc panel decided yesterday, on Thursday, that they were not going to hear the review of the 3-judge panel's case. They gave a robust 1-paragraph analysis, essentially saying, screw you, we're not interested. There was a dissent to this, a 35-page dissent, authored by Judge Van Dyke. Now, for those of you who have been looking at your, baseball player trading cards and looking at different justices like Justice Carney and Judge Benitez, and you probably have come across Judge Van Dyke. Judge Van Dyke is a Trump appointee, and he is awesome. All right, his opinions are very candid. He kind of calls it like it is. Maybe not quite with the rhetorical flourish that Judge Benitez does down in San Diego, but they're still extraordinarily good. In his 35-page dissent, he really takes to task the mindset of the three-judge panel. Now, he doesn't make the argument that I feel is probably the strongest, and I take some issue with him on that. I think that the reason for hearing the case, as I said, should have been that the three-judge panel went beyond their scope of authority. He doesn't mention that at all, which I find to be quite interesting. Instead, he specifically attacks their analysis of Bruen. Now, in it, in the three-judge panel decision, one of the arguments that they start making is, look, we don't need to find laws that existed in 1791 or 1865, during the second ratification of the Constitution. We only need to find laws that are analogous. And more importantly, they may not have to do with anything that we're currently litigating, as long as there was some regulatory environment that we can pull into. So, for instance, one of the things that the three-judge panel cites is that there were laws, few of them, there were laws that were, at the time of the ratification, that said you cannot go onto a private person's property with a firearm as a trespasser to engage in poaching. Okay, this was an it was a hunting regulation. Now, the reason for that, as Judge Van Dyke quite clearly points out, is that if someone were trespassing on someone's estate and had a rifle with them, unless he had a bunch of dead animals in his possession, he could not be charged with poaching. After all, he's just simply carrying his gun for the purposes of self-protection. So in order to get around that, they said, well, you can't be on the property at all with a firearm. Well, the three-judge panel says, okay, well, we can extrapolate this now and say that every private property owner, including a property owner that's opened up his property for public use, think Barnes & Noble or Abercrombie & Finch, they don't want people coming into their establishments with firearms. And since this regulation that dealt with hunting in rural estates back in 1791 existed, we can extrapolate that to say now you can't go into Barnes & Noble with a firearm. It bears no relationship. It's not analogous to. It's essentially they're grabbing at whatever they can grab. Now, the three-judge panel says in their opinion that there is some bizarreness associated with this. They say, look, you cannot be prohibited from carrying a gun in a bank, but you can be prohibited from carrying a gun at a museum. Okay, so this bears no relationship at all to anything articulated in Bruen, but they did it anyways. And they said, look, we understand the disparity. Now, the reason for this is what I have referred to as uncivil obedience. A lot of anti-gun judges are extraordinarily upset about this constitutional test in Bruen because it makes the intellectual gymnastics to uphold an unconstitutional law simply too difficult. And they claim, well, we're not historians, okay? This isn't our job. This I find to be incredibly disingenuous. Keep in mind, cases that go before a bench oftentimes turn on scientific fact. This has been going on now for almost 75 years. Judges are not scientists. In fact, more specifically, I would suggest that a judge is closer to being a historian than being a scientist. And yet they seem to have absolutely no problem at all going ahead and judging on scientifically based cases. But now being forced to engage in historical analysis, this seems to be beyond the pale. Well, again, I think one of the reasons for this is that they say, well, God, we really want to uphold these unconstitutional laws, but now it's too difficult to do so. So we're going to go ahead and we're going to engage in this uncivil obedience, okay? We're going to effectively come up with these disjointed decisions. And this will now make people raise up their hands and say this is completely unworkable and now requires some other form of judicial review that would, in their minds, hopefully cause the Supreme Court to readjust their Bruin test. Frankly, I just do not think that that's going to happen. So, for those of you who live in California or those of you who live in Hawaii, we now have essentially a bifurcated where you can carry a gun. Some places you can, technically, some places you can't. Now, I'm not going to go through the laundry list, but suffice to say, there are going to be independent challenges now on each of these sensitive locations. I don't know how this is ultimately going to play itself out. I definitely know that there is going to be an appeal to the United States Supreme Court. Whether or not the Supreme Court hears the case remains to be seen. Part of that is going to turn on what happens in the underlying case. Keep in mind, the case still hasn't happened. We've only been talking about a preliminary injunction. The case could be fast-tracked at this point, and Judge Carney could issue his opinion that essentially, once again, invalidates all of these sensitive locations, which would then cause the appellate process to continue. So we'll have to see. Everything's still in flux. It is by no means the end of the story, but it's also not a win. It would have been a lot easier for this injunction to, be implemented in its fullness. That did not happen. And as a result, you now have a lot of people that reside in California and Hawaii that are having their constitutional rights abrogated. Not that they haven't been in that position for the last 75 years. In any event, I will update this as things continue. You can always email me at stephen@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.